Hello everybody. Welcome in. Good to see you. Good to see you all. Welcome. Hello, thanks for joining me today. A little bit different time as my summer schedule continues to get sorted out here. Welcome. I am planning to read through more of Mr. Cohen's cross-examination today. We still have quite a bit of transcripts to get through, everyone. It is Wednesday, so we've got Thursday, Friday, Saturday, Sunday. We'll see how things go. And then we've got, of course, the holiday on Monday. So we do have some time to really catch up on these transcripts, which I am really hoping to be able to do, everyone. So thank you for joining me. I do have comments off while I read through the transcripts. It's just easier for me to read through them. It's difficult to catch comments while I'm reading the transcripts. And after I have finished, I will go ahead and turn on a Q&A session for everyone to kind of jump in and ask any questions that they may have. So today, this will be part 2 of the cross-examination of Mr. Cohen, but my 4th live on Cohen's testimony. So part 1 of Mr. Cohen has been posted yesterday on my Tube of You. Part 2 will be posted today on my Tube of You. And I am thinking about doing some lives actually on my Tube of You. I had started to do that a while ago, but I think I will maybe do that once a week now for this summer as well. So I will let you know exactly the date and time for that. But if you have not used the Tube of You live streaming before, it's it's a great program, very interesting, easy to use. The only thing is that your chat will be a little bit different than your chat is here on TikTok. So for those of you interested, just wanting to give everyone a heads up, I will probably be starting that next week, but I will let everybody know. And again, I'm doing that just to kind of broaden what I'm able to say, which is a little bit easier on the Tube of You to be able to do more of the controversial things rather than having to censor everything. Thank you, Taylorina. That's so sweet. So welcome in. I will go ahead and get started here today. I'm planning to just read as much as I can, hopefully an hour, maybe a little bit longer than that. We will see. I've got 2 days of Cohen's Cross actually set to go today. So hopefully we'll be able to get through a lot of that. This will be substituting for my evening post, again, due to my summer schedule. So welcome in, everyone. I will grab my tea here and then we'll go ahead and get started. Thank you so much for all of the gifts, everyone. All right, so let's pick up where we left off yesterday. So yesterday morning, I was able to come on for about an hour. Oop, there's Mr. Blanche. And go through a little bit here of Mr. Cohen's Cross. So let me just refresh everyone's recollection. We were in an afternoon session yesterday when I was reading, and we got started here with the beginning of Mr. Cohen's cross-examination with Mr. Blanche. So we left off then on page 3711, so 3711. We left off where the judge asked if it was time for a break, and everyone had agreed. So this was where we will pick up today. So again, just a friendly reminder, Mr. Cohen is on the stand during these transcripts. This is his cross-examination. His name is at the top here. We have cross-examination labeled with Mr. Blanche, the attorney, asking the questions. At the very top here, you'll see the page number that I'm on as I go through each of the pages here. So sometimes I do skip a few lines when attorneys are offering evidence just for sake of time, but I do try to read each piece as accurately as possible. So again, let's go ahead and pick up where we left off here. We have the judge asking if this is a great time for a break, and Mr. Blanche saying yes. So the jurors were given a 15-minute break. So we will pick up right where we left off yesterday, everyone. Again, I will turn comments on after I finish reading. So here we go. And the judge is just having the jurors come back in after their break here and explaining that they were going to have that Friday off. But I will just pick up straight up at the cross-examination with Mr. Blanche, who is defense counsel in this case. So here we go. Cross-examination again of Mr. Cohen. So we are talking about the first time you met with the Manhattan District Attorney's prosecutors. Was it Otisville, late August 27th of 2019, right? Correct. So you've been in at Otisville for a little over 3 months, is that correct? Correct. Early May of 2019? Correct. Do you recall one of the things you wanted to talk to the prosecutors about when you were in Otisville was that the benefit was to you for meeting with them, right? I did ask that. And you told them that you'd been screwed over by the system, correct? I don't know if that's the language I used, but sounds correct. Well, let's put up, if we can, just for the witness, the court, and the parties, B95. These are the notes. These are notes, not your notes, Mr. Cohen, and you can, if you can look at just the first couple of lines about, so there's 2 initial lines and then a blank space. You can look at the next 4 lines and see if you can make out what's read there, what's written there, rather. Okay? So you wanted to know why you should meet with them, correct? And you're looking at the line that says, why are you here? I was actually looking 2 above that. No response. You can put that aside, Mr. Cohen, it's fine. We'll just ask questions, okay? You wanted to know what the benefit was to you for being there. Nods yes. Which was fair, correct? The reason why, I want to make sure I have this. Right, you were sentenced December 12th of 2018, right? Correct. And we're now in August of 2019, right? Nods yes. That we're talking about a meeting at the DA's office, right? Yes. Are you familiar with the Rule 35 motion in federal court? I am. And you understand that a Rule 35 motion at times gives the judge who sentences you the right to give you a lower sentence if certain things happen, like potentially cooperating, right? That was something that Judge Pauly issued in his decision. And Judge Pauly is the federal judge who sentenced you, right? Correct. So you understood, did you not, that Rule 35 motion has to be made within 1 year of the sentence unless certain privileges pertain, right, or apply? At the time, I did not know that, no. At the time, well, did you later learn that? I did later learn that, yes. Was it later than 2019 you learned that? Yes. During the time, when the motion was actually filed by your lawyers, correct? Correct. So when you were meeting with the district attorney's office for the first time, you asked them what's in it for you, but you also asked them for their timeline, correct? I apologize. Timeline for what? Well, that was going to be my next question, Mr. Cohen. You asked them what their timeline was for this investigation, correct? I don't recall that. No, sir. Did you want to understand from them how long it was going to take them to bring charges? I don't recall asking that. I'm not asking you whether you recall asking that or answering that. I'm asking you, at the time, so August of 2019, did it matter to you how long it was going to take the district attorney to bring charges? No, sir. It didn't? I didn't ask that, and they didn't discuss it with me. Whereupon the senior court reporter is replaced. Continue cross-examination with Mr. Blanche. Okay, I'm not asking if you asked it or discussed it. Did it matter to you how long it would take for charges to be brought in this case? I didn't consider it at the time, no, sir. So you didn't say in August of 2019, what's your timeline? I don't recall saying that, no, sir. Now, you recall that your lawyers had asked them, okay, I'm not asking if you asked it or discussed it. Did it matter to you how long it would take for charges to be brought in this case? I didn't consider it at the time, no, sir. So you didn't say in August of 2019, what's your timeline? I don't recall saying that, no, sir. Now, you recall that your lawyers had asked them whether they would help write a Rule 35 motion with you then? I am sorry, once again. Do you recall a conversation when they were meeting with you, when the district attorney was meeting with you in Otisville about whether the district attorney would be helping to write the Rule 35 motion? My lawyers may have answered that. I didn't ask for it. I didn't say that you did. You were there when they were meeting with you. So while you were there with your lawyers in the district attorney's office, do you remember a conversation where your lawyers asked the district attorney whether they would be willing to help with the Rule 35 motion in federal court? I believe so, yes. Is it fair to say, I know this goes back a couple of years, but the district attorney didn't commit to anything, right? No, sir. They didn't say, yes, we'll do it, but they didn't say, no, we won't. They didn't commit, correct? That's correct. So eventually you met with the district attorney again on September 19th for the second time in Otisville. They came to Otisville, then again on October 30th, correct? Yes, sir. Then in December, your lawyers, in fact, did make a Rule 35 motion in the Southern District of New York, correct? They did. Your lawyer at the time was somebody named Roger Adler. Roger Adler. You had retained Roger Adler in August a few months prior, is that right? Correct. And Mr. Adler put a motion into federal court asking for a Rule 35 redaction in sentence, correct? I did, yes. And you reviewed that paperwork before it was submitted, correct? Yes. So the basis for you, through your lawyer asking the federal judge to give you a lower sentence, was because of your cooperation, is that right? As well as the earlier cooperation, yes. So it was the cooperation with the special counsel's office, correct? Correct. The cooperation with the Manhattan District Attorney's office, the 3 times you met with them, correct? Correct. And then, was it also the cooperation with the Southern District of New York prosecutors? I don't recall the Southern District. I'm sorry, we're talking about a lot of lawyers. You met with a special counsel Mueller's team, correct? Yes. You met with the Manhattan District Attorney's office, correct? Yes. You also met with the prosecutors with the Southern District of New York, the U.S. Attorney's office. I mean, they were there at the meeting with the Mueller investigation. And they mentioned the Southern District of New York. It was not independent, correct? And nobody had signed you up to a cooperation agreement, right? That's correct. And to this day, you've never signed a cooperation agreement. That's correct. Now, that motion was not granted, correct? It was not. So the federal judge, denied your request to have a reduction of sentence, correct? Yes, it was denied. But a little bit later, so now as we move forward, we're talking about May of 2020. May 21st, as you testified earlier, you were released to home confinement because of the coronavirus? Correct. And thereafter, you started speaking to the media pretty regularly, correct? Correct. And you started what you, I believe, called it the redemption tour. Is that fair? Fair. And one of the things that you did in September of 2020 was your first book was launched called Disloyal, right? Correct. That was September 8th of 2020, correct? Yes, sir. Now, right around that time, you launched your podcast that you talked about, Mea Culpa, correct? Now, you on your podcast that started September 14th of 2020, does that sound right? Sounds correct. On your first podcast, Mea Culpa, you referred to President Trump as the boorish cartoon misogynist, didn't you? It sounds like something I would say. And those types of comments and names continued on, every single one throughout 2020, correct? I'm sure I said something. I can't say that they are all. You recall the first one in 2020 as a Cheeto-dusted cartoon villain? That also sounds like something I said. Now, do you recall around that same time in October of 2020, you started talking about your hope that President Trump would be convicted of a crime, correct? I don't know if those are the exact words that I said, but the sentiment is correct. You think you might have said, I truly effing hope that this man ends up in prison. Is that exact? That sounds like my language on Mea Culpa. Just so I understand, this is now October 2020. The last time you had met with the Manhattan District Attorney's Office was about a year earlier, is that right? Correct. So you met with them 3 times in Otisville. You applied to get a sentence reduction, which was denied, and then you were released because of the coronavirus to your home. But you were still serving a federal sentence at that time, right? Correct. It's just that instead of being at Otisville, you were in your co-op condo. Your condominium condo. I believe you have headphones right to your right, and I think the parties do as well. I'm going to ask you to put the headphones on. I would like to play a portion of B25, which is a Mea Culpa, a portion of the Mea Culpa podcast on October 23rd. Mr. Cohen, I would love for you to listen to I would love to tell you I would love to tell you how to use them. You turn the very top up, points it towards, do you hear it? You heard that, Mr. Cohen? I heard that. Whereupon the witness, Michael Cohen, listened with the headphones to the above referenced audio recording. Your Honor, may we approach for a moment? Yes. Whereupon the following occurred at sidebar. This tape is apparently an hour long. I could tell from the screen. I was just given the thumb drive. I haven't had a chance to review any of it. I don't have the rest of it. She was just handed the thumb drive now. Yes. I can just get back to this tomorrow. I'm not looking to introduce a lot of things, just 2 or 3. They haven't had a chance to look at it. I literally just gave it to them. I'm happy to go on. Thank you. Whereupon the following occurred in open court. Continuing cross-examination. What you just heard was a portion objection. I will allow him to clarify it. Sorry for speaking. What you just heard is a portion of your podcast, Mea Culpa, from October 3rd of 2020, correct? Correct. You also said in the same podcast, did you not, that President Trump needs to wear handcuffs and to do the perp walk. People will not be satisfied until this man's sitting inside the cell. Do you recall saying that? I don't recall saying that, but I wouldn't put it past me. By the way, as of October 22nd of 2021, which is about a year after you'd started your podcast, you started in early September 2020. Now we're talking about October of 2021. Your podcast had top 10 million downloads. Does that sound right? I think it was more, but yes. You said you think it was more. The average was around 300,000 a week. Is that right? Something like that, yes. I am sorry. Something like that. And you make money off the podcast, correct? Yes, sir. And then, by the way, is it fair to say that you are motivated by fame? No, sir. I don't think that's fair to say. Is it fair to say that you're motivated by publicity? I don't know that that's fair to say. I'm motivated by many things. So do you recall saying in Disloyal, which is a book that you published the year before, we're talking about now September of 2020, you published that book, right? I did, yes. Do you recall saying that you had wealth, but that you wanted power, the good life, public acclaim, big deals, fast cars, private planes, the excesses and the glamour and zest for life? Do you recall saying that? Yes, sir. So is that what motivates you, what I just read? Yes, those are my words. You also, correct me if I'm wrong, loved being on CNN, MSNBC, and even Fox TV when I was speaking on behalf of Mr. Trump? Well, let's do both. Did you love it when you were speaking on behalf of President Trump? Yes, sir. Do you love it now? Less, but yes, still do. So the answer is yes, you love it, although just less now than you're used to. Yes. Fair to say in the first few months after Disloyal was released, you made about $2 million off that book? Sounds correct. You put that money into a trust for your family, correct? It went into a bank account. So after meeting with the district attorney 3 times in 2019, the last time being late October, you didn't meet with them again. So you didn't meet with the Manhattan prosecutors again until January 11th of 2021. Does that sound right? They didn't ask to meet with me again until that date, yes? I didn't ask you whether they asked you to meet with them. My question was a lot more basic than that. Just factually, between August 30th of 2019 and January 11th of 2020, you did not meet with the Manhattan District Attorney's Office? No, sir. They didn't ask you to meet with them, correct? No, sir. Is it fair to say that in your first call after you had gone from October 30th of 2019 to January 11th of 2021, in your first call on January 11th of 2021, you thanked the new DA team for continuing their investigation, didn't you? Sounds correct. You told the prosecutors the very first time in January of 2021 that you had a strong desire to hold President Trump accountable, correct? That sounds correct. At the time, there was somebody who was working at the district attorney's office who is not at this table named Mark Pomerantz, correct? He started meeting with Mr. Pomerantz and the others just after the January meeting after that January meeting in February of 2021, correct? Sounds correct. Were those meetings, that was during COVID, were those initial meetings on Zoom? I believe one was on Zoom, yes. Do you recall that you met twice in February of 2021, February 18th and February 26th of 2021? Again, it sounds correct. Well, do you want to see something to refresh your recollection? Sure. If we could look at first B73. Your Honor, may we approach for a minute? There was a sidebar discussion. Yes. Mr. Blanche is now asking about another investigation that occurred in the office related to financial conditions. If he wishes to open the door, I guess that door will be open to that. Given that it is not yet opened, I would caution that if he's asking all about those meetings did not have to do with this same case. I'm not asking him about the specifics of what he spoke to the district attorney about in February. I'm asking if he did meet with them. The implication is that he met with them to discuss the case. If it doesn't open the door, I'm happy to make it crystal clear it wasn't about this case. If it was about a different investigation, I don't want to open the door. You can clarify it wasn't about the case, and that won't open the door. That's fine. That will not open the door. I will clean that up. One person at a time. If you clarify it was not about the case, it will not open the door. Okay. Whereupon the following occurred in open court. So, continuing to talk about February of 2021 time frame, you were meeting with the district attorney of Manhattan, but it wasn't about this case, correct? Sounds correct. And you didn't, so you said a few minutes ago that the district attorney hadn't asked you to come and meet with them in that time frame, right? Meaning that between 2019 and 2021, you hadn't been asked to meet with the district attorney, right? That's correct. If they had asked, you would have cooperated and come in, correct? Presumably so. And you wanted during that time period, and you were asked this on direct a little bit, but I want to talk about it a little bit more. In 2021 time period, early part, you wanted the district attorney's office to publicly acknowledge that you were cooperating, correct? I would say so, yes. Well, I'm not trying to put words in your mouth. Would you say so? Do you have any doubt that you wanted that? No. And you're still serving your sentence at home, is that right? I'm still on supervised release. But your 2021 sentence is over? November. Of 2021? Of 2024. I am sorry. So when you get home, you're still serving your sentence because of COVID. When did you go from prison to supervised release, even if it was still in your home? November. Of what year? 2021. So in the beginning of 2021, we're talking about the first 5 months, you're still serving your sentence, correct? Yes, I'm still on home confinement. And the rules with home confinement meant you weren't allowed to leave your home except for certain times for certain things, correct? Yes, a certain number of hours per day that I can be outdoors. You were allowed to go places, but not anywhere you wanted, right? Anywhere in Manhattan. So what was your restrictions when you were still serving your sentence? Other than those 3 hours, I was at home. So 3 hours, 7 days a week? Correct. You were allowed to go anywhere in the borough of Manhattan? Yes. Did you have to wear an ankle bracelet? There was an ankle bracelet at first, which then became a phone. A what? A telephone. So the Bureau of Prisons tracked you on your phone. So when you were not at your home or when you went out for 3 hours, that's how the Bureau of Prisons tracked you? Correct. That way they knew you had your phone on you, and they would call you, right? Yes. Did they randomly call you? They did. So during that time, and again, I don't want to get mixed up on the years. Correct me if I'm saying something wrong. But during that time, that first half of 2021, you wanted the district attorney to publicly acknowledge your cooperation. You were trying to get your sentence, even though you were just on home confinement, lowered, right? I was looking for a reduction in the home confinement portion, not just from this, but also as a direct result of my work that I had done while I was in Otisville in terms of work and programs and credits. I should have been entitled to a year, but I received none of that either. Just so we understand, you're saying that you believe that there had been a calculation that had been done by the Bureau of Prisons that maybe wasn't accurate? You were entitled to be released earlier? Is that what you're testifying to? Pursuant to the Bureau of Prisons, you get what's called work credits as well as education credits, to which I put in an application to the Bureau of Prisons as well, which never amounted to anything. And that would only be for the home confinement portion. But correct me if I'm wrong, one of the reasons why you wanted the district attorney's office to publicly announce or talk about your cooperation was to help that effort, correct? I would have used that, yes. And the goal was to be released from prison early, even though prison was different. You weren't in Otisville, you're just at home, right? I did want to be released, yes. I have to pause here, everyone. I think this answer here, we've talked about this before. We had one flag yesterday when he talked about the definition of lies. I would count this as the second flag from Mr. Cohen, all right, where he's discussing how he didn't think his sentence was properly implemented. So we can talk about that later. And you talked about this on direct, but ultimately there was no letter or public announcement made by the district attorney about your cooperation, correct? That's correct. So again, talking about the 2021 timeframe, you are still under the terms of imprisonment, at least until November, right? You're doing your mea culpa podcast from your home, correct? Correct. And you were meeting with the district of attorney from your house, or did you also go down to the district attorney's office? Possibly a combination. You were also going on TV during that time, as we talked about an hour ago or so ago, talking about the fact that you're meeting with the district attorney, correct? Yes, but I don't believe when I was on home confinement that I was doing television. I would have to double check that. You don't remember on January 17th of 2021 being interviewed by MSNBC by someone named Ari Melber? You don't remember that? I don't specifically remember that date, but I have been on Mr. Melber's program many times. And do you remember the next month on February 22nd of 2021 going on MSNBC and being interviewed by somebody named Joy Reid? Yes, I've been on Miss Reid's program many times as well. But just so I understand, I'm talking about 2021. Do you believe you were going on TV in 2021? Yes. And then in November of 2021, your sentence is over and then you are on supervised release, correct? Correct. Can you explain what fundamentally changed when your sentence ends, given the uniqueness of the coronavirus when your sentence ends and you convert to supervised release? With the home confinement for those appearances on television or to meet with the district attorney's office or anything outside of 3 hours that I was provided access, you fill out a form to your probation officer and you wait for approval. Supervised release is less stringent. Basically, you check in once a month on a form, and if you're going to leave the state or the country, you still have to provide them with notice via an authorization form. And that second part of what you're just talking about, that started around November of that year, right? That started when I was returning home. And you're still on supervised release until November of this year, correct? Correct. You understood at some point during this investigation process that there was a new district attorney, correct? Correct. And you at the time have spoken about that district attorney, correct? Correct. And you have met in person with District Attorney Bragg? No, sir. Then in October of 2022, now we have another year gone by, you published your second book, Revenge, correct? Correct. How much money have you made from Revenge? I don't know exactly, but I would say around $400,000. And knowing that, and then in the first 2 months or so of Disloyal made around $2 million, combining the two books, how much more did Disloyal make after the $2 million that it had made in the first couple of months? Maybe another $1 million. You made, I'm not expecting you to be exact, you made about $3.4 million from those two books. Is that fair? Over a 4-year period? Yes. It is, sir. Yes. It is. Yes, sir. So that's over the past, 4 years, the last 4 years. Yes, thank you. So after you published the book Revenge, by the way, you talk about that book, your frustration about Trump not being prosecuted, don't you? I say things like that, yes. And you say, for example, you don't understand why nobody will hold Donald Trump responsible, right? That sounds correct, yes. And you talk about it in your book about your efforts at cooperating with special counsel and with the Manhattan District Attorney's Office. I talk about my cooperation with them, yes. Now in the book, you call yourself a fixer, right? I probably referenced it, yes. But when you think of yourself as a fixer, are you fixing things that you broke? No, sir. There came a time when you became concerned that the new district attorney was circulating negative stories about you. Objection, Your Honor. Overruled. Can you repeat that? Did there come a time when you became concerned that the new district attorney was circulating negative stories about you? Yes. And you talked about that in your book, right? Yes. And you said that the articles were saying people familiar with Bragg's thinking were circulating stories about you. Objection, Your Honor. Sustained. Now, we talked a little bit earlier about that time period, just over a year and 3 months ago, so January of 2023, That's towards the end of the month when you turned over your phone to the district attorney's office, right? I'm sorry, I'm confused by your question. We talked about earlier, January of 2023, so a year and 3 months ago, that when you gave your phone, consented to have the district attorney's office come and get your phone and take them, right? Yes. You gave them your password? I did. You signed a consent form? I did. And an investigator, Rosenberg, came twice. The first time and a few days later and got both your phones? Correct. It was around that time, a little before the end of January, that you started texting regularly with Investigator Rosenberg, correct? No, sir. I would disagree with the characterization of regularly. Mr. Blanche, this might be a good time to stop. Absolutely. You're going into a new area? I am. Let's stop now. Jurors, I ask you, please, not to talk amongst yourselves or with anyone else with anything related to this case. So at this point, the court does stop for the day. So rather than reading through all of the jury instructions that I have read through multiple times here, we will just go ahead and move on. There is a bit of a discussion, a pre-discussion here regarding the experts that defense is wanting to add later, but it's very brief. I will move on then to our next day of testimony involving Mr. Cohen's cross-examination then. So here we go. Oops, how'd that get there? All right, just to remind everybody, this is Mr. Blanche here, Mr. Cohen here being cross-examined. And there we are. So next page, next day, this would be May 16th. So we will continue on with Michael Cohen's cross-examination. But before we get into his cross-examination, of course, we have the proceedings at the very beginning of the day. So this is, I think, very interesting, an interesting discussion between the lawyers and Judge Merchant. So I will go ahead and read through this. So we have the proceedings, and we're starting on page 3750 here. We have a sidebar discussion that is continuing on. So one moment here. All right, so let's get started. Defense, or the state is speaking here. We have additional objections at this time, Judge. Do you want it to happen in open court? I think I would rather that we remain at sidebar, but unless you're preferred to do it in open court, you can decide once I explain. The press doesn't like it very much. They will be able to read it later, I would assume. Your Honor, based on defense counsel's proposed jury charges, we understand that they will likely be asking Mr. Cohen today about Judge Furman's recent decision in the Southern District of New York. We understand that he may be able to inquire about it, but we would object to the decision going in as being extrinsic and collateral. Also, we do think that if they go into that, meaning Judge Furman's decision, not that he testified to, that we would be on direct seeking to admit Judge Engeron's decision about that testimony. So we have some issues going on here with Cohen's testimony. They're starting right at the sidebar. So I just wanted to preview that. A couple of other things just before the testimony continues. I don't know if we can do this on the fly as we go, but I also wanted to preview it for the court. Defense counsel provided us with a number of exhibits. As you know, you may not know, there are some clips on Tuesday, but now there are, I may be wrong, but maybe close to 50 clips relating to Mr. Cohen's either TikTok or other programs, podcast programs. We have only the full clips. I asked for the full clips for some of the exhibits that Mr. Blanche told me he was going to seek to admit. We don't have the full clips for the others, but I didn't know that he was seeking to admit them. He may be seeking to use them. Of course, the witness may not really be able to determine what else was said on that podcast, but we have some very specific objections for some of the clips that Mr. Blanche may seek to admit. One is there's been a significant testimony about Mr. Cohen's bias. About what? Mr. Cohen's bias, his hostility towards the defendant. his making money off of the defendant. And we did not even object to the exhibit relating to some of his merchandise. We felt that if it was going to come in any event, but if the merchandise there are pictures of the defendant behind bars in an orange jumpsuit, enough of that has come in at this point. A number of those clips we think are precluded by Your Honor's decision on the motion, on the people's motion in limine, which is they reference opinions about whether he should be in jail and whether he should be in handcuffs, whether he should have a mugshot taken. First, our office did not take mugshots, did not take fingerprints. Mr. Cohen probably is not aware of that. It's not something that he may or may not be aware of. But at this point, we really think this is intended to elicit something quite improper for the jury. And so B35, just to go over a few of them, B35, the other thing is that they were taken out of context. So, for example, B35 had Mr. Cohen talking about, something like mental excitement, about seeing him in an orange jumpsuit, which is what they have exerted. That's what they haven't included, is just before that clip and just after that clip, him saying that's not appropriate. That's not what we should be wanting. What we want is accountability. What we're seeking only is accountability. We should be seeking due process, a fair jury, a fair judge. So the context has been excerpted out of it. We were left with an excerpt of a clip talking about excitement about seeing him in a jumpsuit, which, again, we think Your Honor has precluded evidence of potential punishment or consequences in this proceeding. So if that is admitted, we object to it. But if it's admitted, we're going to seek a redirect to submit the clip and its context. And there are other clips. The other clips are similar in many ways. Perp walk, handcuffs, etc. Your Honor, we've provided all the clips to the defense. Most of them. To the prosecution, thank you. That's okay. That's all right. I feel the same way sometimes. To the prosecution, most of them on Tuesday, more yesterday. We were not seeking to offer virtually any of them. They are just to refresh his recollection. Now, the people are correct. There are a few that we want to offer. We look the law. I don't need to pass it up to the court, but evidence of bias is always admissible and extremely important. And extrinsic evidence of bias is always admissible. And of course, the court can limit it appropriately. And we are being judicious in our view, and we are not offering 50 clips of him saying things. We have a handful that are targeted at his actual, in our view, his actual bias. We are talking about, I believe we're seeking to actually admit 3 or 4, maybe 5 short clips. That is out of hundreds that we could potentially seek to admit. So evidence of bias is admissible. We have a ton of evidence of bias, and we're seeking to admit extrinsic evidence of bias, which we are allowed to do, and in a handful of cases, that's fine. But if it appears that you're taking that out of context, I have certainly no problem with the people going back into it on redirect. Sure. And showing that you took it out of context. Your Honor, I very much appreciate that there's evidence out there from Mr. Cohen that they would want to offer on redirect, and them stating that I'm opening the door to his bias. I'm not suggesting is the opening of the door for that evidence. Regarding Judge Furman's decision, are you going to bring that out? No, but I don't know how he's going to answer the questions. What I intend to ask him about is what happened with the AI case, the situation, and it is just that, what happened, and then ultimately ask, like I'm doing for all of his attempts to get out of supervised release early, just to ask whether that was denied. I'm not asking anything about his findings or anything. Okay. Because I believe that that's not allowed. It's just not. The Angron finding is not allowed. All right. Just 2 other things. I apologize. One of the clips that they're offering talks about Mr. Cohen from 2020, talks about Mr. Cohen's, the cases that are, the investigation that he believes are out there, meaning the Southern District investigation and the AG's investigation and the investigation by our office. And he talks about speaking with our office about all sorts of financial crimes. So if that does come in, that does open the door, Your Honor, because that was ongoing into 2021, and that was on the clip. So he would certainly seek to clarify about that, so it will open the door, and we will argue that it does. Tea break, everyone. Well, it's a short clip. he does make reference to the fact that he has gone to the district attorney's office about all kinds of financial crimes as well. To the extent that the people believe that opens the door to them redirecting him on evidence of financial crimes, then that certainly opens the door to a whole series of questions that I did not ask about. What this district attorney thought about his testimony with respect to those financial crimes, I mean, it's not admissible. Look, all I'm going to say, as with everything else, proceed at your own risk. I can't rule right now. I haven't heard the question and I haven't heard the answer, but proceed at your own risk. If the question and the answer leave the jury with an impression that may not be entirely accurate, the people will say that the door has been opened and I will rule that then. I don't understand what the people are saying and what the court's decision is. You would have an objection to even me asking him you were meeting with the people about more cases than just this one and having him say yes to that? I'm not trying to hide that from the jury, but if they don't, then what would be your concern with that? Well, I do have a concern about that. Right now, we're trying this case, and I think Your Honor has precluded all of the rest. We're talking about a tax case. We're talking about statements of financial conditions, and I think that opens the door. I just think that I wanted to bring it to the court's attention that this particular clip talks about all other financial crimes that he was involved in, and it's in their clip. If they do it, we might have to make some decisions, and that's including the question, I guess, is whether, if it's out there, whether the defendant gets cross-examined on that issue. Now, I know Your Honor has made a ruling. I wanted to bring it to the court's attention. A decision hasn't been made, but I did notice it on the clip, and I think it presents some issues here. It is on the clip, and you know we very much believe that the court will hear the clip, that it's not confusing to the jury, especially if we elicit. Let's see how it comes out. Pardon me? We will see how it comes out. Yeah, sure, understood. We can all make all the arguments we want, but we won't know what's going on and what it's going to look like and what it's going to sound like. So let's wait on that. One more thing, Your Honor, and that's it. I believe the defense is offering B45, which is text from Jeremy Rosenberg and Michael Cohen. They are excerpted, only certain portions of the text that, without context, the context that they've excerpted out are all of the very serious threats that Mr. Cohen was receiving, including some unalive threats that Mr. Rosenberg had to follow up on and our office had to investigate. If they're seeking to admit texts out of that nature, well, first of all, we object. We don't think that this should come in. Your Honor had a concern about too much evidence coming in about threats to witnesses, especially because we have a jury who may be concerned. But we are going to object to that exhibit. There is one portion on the first page that's just about phones, which would be admissible, but the rest of it is all about Mr. Rosenberg's trying to make him feel better, given all these threats that were happening. So we would object, and if it's admissible, we would like to put in all of the threats. Mr. Blanche, this is Mr. Blanche here. Sorry, everybody. Hold on. Apologize. OCD. Your Honor, we redacted it for the reasons that the people just said, that there is some back and forth around threats. The excerpts that we're offering are 100% in our view continue to go with Mr. Cohen's bias. They are accounts about Mr. Rosenberg and Mr. Cohen talking about holding President Trump accountable. I believe he will hold him accountable. And then a further question about the fact that Mr. Rosenberg knows about Mr. Cohen's father. We're not going to get into any details about that, but it goes to show the relationship that Mr. Rosenberg and Mr. Cohen had. So much so that there's a witness and the detective knows details. And we're not getting into the details about his father. We're not getting into that. Just to point out that they had a very close relationship. As the court knows, the phones are an issue, and that's why we're trying to bring it out. What you're describing, and I'm handing it up, okay? I can hand up the exhibits, Your Honor, the redacted and unredacted versions for you to review. Clearly, it goes into the witness's state of mind, so they can't bring in texts that are in response to the threats because they then are not bringing in fulsome understanding of his state of mind at the time. I agree with that. I would ask them to represent which one that we're offering is a response to the threat. Sure. At the bottom, where on your redacted version, I think the court can see this on page whatever. For some reason, I stapled it wrong. There's a discussion about, quote, staying strong. I get it. I truly understand the incredible turmoil you're experiencing, quote. Michael Cohen says, believe me, it's worse than you can possibly imagine. And you've redacted all of the threats, the telephone calls and the calls to his wife and the threats that he received from someone who was with an online program. So I think the judge will be able to see exactly what's redacted. So it sounds like that if you want to establish a state of mind and you want to establish something about the relationship, I suggest that you do something appropriate about the relationship, which is fair, which is fine. I think the people may very well be able to elicit why the investigator was trying to comfort him and trying to reassure him. And we will be asking to put in the full version. That's what we will be seeking to do. We provided these to the people midday yesterday. I think if we could have gotten an objection to a few of the lines like that one, if it was anticipated, we would have been able to agree to redact. I'm getting into this right away, actually, so if I could have 2 minutes, I can just go and make sure that it's out. Just so the record is clear, I would say that you sent me the redacted version of this exhibit at 9:38 p.m. last night. The original version I didn't object to, but the redacted version you sent late last night when I asked for it was what I'm objecting to. So you need to take a moment to fix that. Excuse me? You need 2 minutes? Yes. So going forward, please don't wait until I come down to discuss these things. All right. If you want to come down in advance to discuss issues like these, I can come down earlier. Thank you. Just 1 second before you slip away. The schedule's a little bit up in the air right now, and as you know, we have some pretty large breaks coming up because of graduations and travel plans and the holidays. So this is the moment you should plan on working next Wednesday. We should plan on working on Wednesday? It may not happen. It could be that it won't happen, but right now you should plan on it. So that is very much fine with us. I will tell you that we have a hearing scheduled in the Southern District of Florida on Wednesday. Now we are only part of a very small motion, and our intention was to seek permission from Judge Cannon that President Trump be excused. In the past, she's agreed. We will obviously state that the trial is ongoing. I do not anticipate that she will say no, but just so the court is aware, there is an oral argument scheduled. Obviously, we will, if we are sitting here, we won't be there, and I'm okay with that, and so is Mr. Bove. We have local counsel who can cover, but we will try to work on putting that letter in today. We won't say publicly that it's before the court, so we will be careful. Now, when I get back and I looked at the motion in limine again, my decision on the motion, nothing has changed. If you want to make further argument, if you want to change something, that's fine, but I haven't heard anything yet at trial that would change my decision on that issue. Understood. And we may have, I don't think we're going to address at 4 o'clock, Judge, is a proffer from us about what we would seek to elicit so that we can have a sense of whether it's going to be worthwhile to do this. All right, we will do that after the jury's excused today. Yes, Your Honor. Yes, Your Honor. Are you going to ask the jury about their availability on Wednesday? Yes. So what I would normally do, I just tell the jurors, look, it's a possibility we may need to work on Wednesday. Would that present a hardship for any of you? If it does, raise your hand. I'm not crazy about putting them in that position, but I prefer to do that rather than to have a court officer or somebody else ask those questions. Okay. Judge, may I raise another issue? It's very short and I apologize. On Tuesday, some of the defense guests filed in the middle of direct examination with their security detail. And I noticed that some of his guests are already here today with their security detail. But we would just ask that they not be allowed to file in the middle of Mr. Blanche's cross-examination. It's with their security detail for the jury and the witnesses to see. Yes, I would advise that not happen. Your Honor, I have less than zero control over what's happening on anything or anyone that's behind me when I'm crossing a witness. I don't have any control over that. I mean, they are members of the public. Are you expecting anyone else today? Your Honor, I have no idea. No, I'm not expecting anyone else, but I might be wrong. Oh, okay. Sidebar concluded. I apologize for all of the whispering. I think we may be able to get started. Was there anything else that you wanted to go over with the court? No, Judge, thank you. There was nothing else. I just wanted to remind you that I asked for 1 minute to deal with something. Sure. Thank you, Your Honor. Are you ready? Yes. All right, let's get the witness in, please. And so now we go through the process of seating Mr. Cohen again, and we will pick up on cross-examination. I think it's very helpful to have the sidebars, that sidebar information, to get a full picture of what's really going on. A lot of things happen during sidebars, everyone. All right, here we go. We're going down into Mr. Blanche asking, may I inquire? And the court saying yes. So thank you, Your Honor. We will pick up our cross-examination. Good morning, Mr. Cohen. Good morning. So when we stopped on Tuesday, we had just started talking about an individual named Detective Jeremy Rosenberg. Do you remember that? Yes. Who is he? He works with the district attorney's office. Was he, going back a year or so into the beginning of 2023, was he one of the detectives that you interacted with for when you were coming to court to meet with the prosecutors to get your phones, that sort of thing? Yes, sir. And did you text with him? I did. And you texted with him on his work phone, correct? I believe so, yes. And you also texted with him on a different phone, his personal phone, correct? Correct. Now, just to remind the jurors, Mr. Rosenberg came on 2 separate occasions in January to pick up your phones, which you had consented to the district attorney to do, correct? Correct. And I'm going to show you, just for you, the parties, the court, what's been marked for identification as B117. And I'm going to ask you to take a look at that. Do those appear to be texts to you, some of the texts that you appeared to have with Detective Rosenberg? Yes, sir. Now, these aren't all of the texts, though, correct? What you're looking at? So far, no. Judge, may we approach? Sure, at sidebar. Judge, there are addresses all over these texts that are not redacted. We're not looking for or at the addresses. I know, but it shouldn't appear for the defendant and all of those behind him, presumably. I will take that down. Please take those down. Thank you. We can take down the exhibit, please. Can we put up the redacted version of B118? B118 in private only, Mr. Blanche. That's in private only. Yes, and we don't have to put that up there. That's my fault. That's my fault, miscommunication. Can we put up B45 just for the defendant, the parties in the court? I'm sorry, the witness, the parties, and the court. Take a look at this, Mr. Cohen, again. This is a couple of pages. So do you recognize those as being, again, those are redactions, but some of those texts that you had with Detective Rosenberg last year? Yes, sir. And did those, knowing those redactions, do those texts accurately reflect what you wrote to him and what he wrote to you about a year ago? Yes, sir. The defense offers B45. May I have voir dire, Your Honor? Sure. Voir dire examination by the state. So she is trying to clear up foundational questions here. So she will be asking Mr. Cohen a couple of questions. Mr. Cohen, when you say they accurately reflect your communications with Mr. Rosenberg, are there large spots that are redacted in these texts? Yes, ma'am. And are they therefore out of context without those unredacted portions? I believe so. We object, Your Honor. Please approach. So I again sustained an objection. I'm going to allow it in and give you an opportunity to then go back and reread it if either party wants to do that. I think we should keep it out. I mean, Judge, let's not use the unredacted version or put it in the fully redacted version or put in the fully unredacted version, your choice. I believe it's appropriate, Your Honor, on redirect. If they believe that there's something that is taken out of context that they want to offer it, then they can. But it's just that this is just the people's belief. Except that right now we have knowledge of it in advance before it even comes in. We know in advance it's going to be taken out of context, and we know that you have an unredacted version that you can offer. I don't think it makes sense for us to just play that game. Why don't you just go ahead and introduce the unredacted portion? I will sustain the objection to this document. Thank you. Sidebar concluded. The objection is sustained. Continued cross-examination. So the text that you just read between you and Mr. Detective Rosenberg, those were around the time that you testified to the grand jury in this case, correct? Correct. Now, and you saw the text just now where you and Mr. Rosenberg, Detective Rosenberg, were discussing how you were going to hold President Trump accountable, correct? Objection sustained. Now, you recall the leak. There was a leak that the indictment had been returned in this case. Do you recall that? Objection, Your Honor. Overruled. You can answer. I'm sorry, one more time, please. Do you recall that prior to the indictment being unsealed in this case, it was leaked to the media? Do you recall that? Objection, Your Honor. Can you please rephrase? Do you recall whether prior to the indictment being unsealed, the public learned that President Trump had been indicted? Yes, sir. And did you yourself learn that President Trump had been indicted prior to it being unsealed in this courtroom? Yes. And you learned that from reading that. You learned that from reading the New York Times. Is that fair? Yes, sir. And Detective Rosenberg confirmed it to you that the New York Times story was accurate, correct? Objection, Your Honor. Overruled. You can answer. I'm sorry, one more time, please. Detective Rosenberg confirmed to you that the New York Times article was accurate and that President Trump had been indicted, correct? Objection. Sustained. Did Detective Rosenberg confirm that it was done to you? I'm sorry, I don't understand your question. Sorry, I need a tea break for a moment. Well, let's just put it up, just for you, the court and the people. B45 again. Does that refresh your recollection that Detective Rosenberg told you that it was done, meaning President Trump had been indicted? He identified a newspaper article. Your testimony is that the text you just read was Detective Rosenberg identifying a newspaper article? That's what it says, yes. Detective Rosenberg didn't tell you that they told the New York Times before they told you? Did he tell you that in a text? I'm sorry, I don't understand your question. It's confusing. Did Detective Rosenberg tell you before the indictment was unsealed in this case that they had told the New York Times about the indictment before they told you? Objection. Sustained. When you say they, who are you referring to? Well, that was going to be my next question to this witness, Your Honor. Do you have an understanding about whether Detective Rosenberg told you about the indictment before it was unsealed? No, sir. He didn't tell you before that there was an unsealing in this courtroom that it was done, meaning President Trump had been indicted? Asked and answered, Your Honor. Overruled. You can answer. No, sir. Are you sure about that? Yes. So when did you learn about President Trump getting indicted? From the New York Times article. And did you have communication with Detective Rosenberg about the New York Times article? Yes, sir. And what did he tell you? He stated, well, I asked him or texted him, nice to find out through the New York Times article, nice for a heads up. Isn't it true that he had texted you, I know you heard, and you said, nice heads up, huh? Tell the Times first. Objection, Your Honor. Sustained. Did you sustain the objection? I did. So your testimony, sir, is that you did not hear from Detective Rosenberg before it was unsealed. In this case, the President Trump had been indicted. I don't recall hearing from Jeremy Rosenberg that, no, sir. Now that same day, March 30th of the last year, okay, you went to CNN, correct? Yes. And that's when you said on TV that this indictment in this case was like David against Goliath. Do you remember saying that? Yes, sir. And when you said that, you were describing yourself as David and President Trump as Goliath, correct? Correct. And you actually said on March 30th, so before the indictment was unsealed, that you had Goliath on his back, didn't you? Sounds correct. And that same day, Detective Rosenberg complimented you and said you were so sharp and competent, saw the fantastic interview on CNN just now. Objection. Sustained again. Your Honor, may we approach? Yes. Apologize, everyone. Your Honor, may we approach? No. Do you have a recollection, Mr. Cohen, of Detective Rosenberg texting you about your appearance on CNN? Yes, sir. What did he tell you in that text? Objection. Sustained. Do you recall on March 31st going on TV with a reporter named Joy Reid? Yes, sir. And again, this Friday, March 31st, so it's when the indictment is still under seal, correct? Yes, sir. And do you recall Detective Rosenberg complimenting you about your interview with Joy Reid? Objection, Your Honor. Overruled. You can answer. Yes, sir. Now, that was at the same time that the Manhattan District Attorney's Office was telling you not to do TV, correct? Correct. Now, do you recall going on your Mea Culpa podcast right about that time on March 30th of 2023 and talking about the indictment? Yes, sir. So I want to play for you in the parties and the court B46. So I think you have them. Do you have the headphones there, Mr. Cohen? Audio tape being played at the aforementioned parties only. Were you able to hear that, Mr. Cohen? Yes, sir. Please use the microphone. Yes, sir. Were you able to hear that? And that was your voice. That was just a portion of that podcast, right? That was just a snippet, right? Yes. And that was on May 30th of 2023, correct? Correct. Your Honor, we offer B46 just for reasons discussed at the bench. We object. As addressed at the bench, the objection's overruled, and we will accept it into evidence. And if we can play that for the jury now, B46, thank you. Audio tape being played in open court at this time. Now, you said on that podcast that you wanted to thank the Manhattan District Attorney's Office and their fearless leader, Alvin Bragg, with whom you spent countless hours, but you never met Alvin Bragg, correct? That's correct. And what you just said about picturing President Trump being led through the booking process and whatnot, that wasn't the first time, meaning May 23rd of 2023. That wasn't the first time that you said you wanted President Trump to get a taste of what you went through, right? Correct. So do you remember in a podcast on October 23rd of 2020 where you discussed similar things? Do you remember that specifically? No, but I'm sure I did. Well, let's take a listen. Audio tape being played for the aforementioned parties only. You heard that portion of your podcast. Again, that wasn't your whole podcast, correct? Correct. It was just a small portion of that. That was your voice on October 23rd of 2020, correct? Correct, it is. Defense offers B25, Your Honor. Based on the court's ruling, no objection, accepted into evidence. If we could play B25 for the jury, thank you. Audio tape is being played for the jury. And now you said on October 23rd of 2020, right? So that wasn't around the time of the indictment in this case, correct? Correct. Now, in that same podcast, would it surprise you to learn, and you also said you're not going to lie, thinking about Donald Trump and his family sitting in Otisville prison makes you giddy and with hope and laughter? Sounds correct. And so in that instance, just to remind the jury, Otisville is a federal prison that you spent about a year at. Is that correct? That's correct. All right, everyone, I'm going to go ahead and pause. I don't think I'm going to be able to make it through. We have been reading for over an hour. Oh my gosh. Let me go ahead and turn on comments here so we can do a Q&A. Thank you all, of course, for joining me during our reading here of Cohen's cross-examination, but I do want to make sure I've got time for follow-up Q&A. So here we go. We go ahead and turn the comments on. Welcome in, everybody. Thank you all for joining me. Thank you. Good to see you all. Welcome. Hello, everybody. Hello. Oh, you're most welcome. You're very welcome. Thank you all again for coming by. Here's another picture here, Mr. Cohen. Will you read again? Yes, I most certainly will. Yes, I will. Why doesn't the record show what the audio says? Great question, and that's because the audio has been admitted into evidence, and if it is in evidence, then it can be reviewed verbatim as a piece of evidence, so the court reporter doesn't have to go through and type out all the words. So it's quite different court reporting what people are saying as opposed to court reporting an audio tape. It's a very different process. It's actually much more difficult. Appreciate you reading this. Oh, you're welcome, Karen. You're welcome. How do you know the jurors did not fall asleep listening to all that? We don't. We have to rely on the people in the room saying, we don't see any of the jurors falling asleep. How much of what Cohen said on the podcast could sway the jury's decision? That's a good question. There's really no way of knowing. I think anytime your own words are played in court, definitely has an effect on the jury. So if it's Mr. Trump's own words or Cohen's own words, it definitely hits different to a jury. But, again, he's saying this on a podcast, a couple of years ago. I don't know how much that's really going to influence it. I think the whole point, of course, is that Mr. Blanche is trying to show Mr. Cohen's bias against the defendant, which is one of the rules of evidence. If you have a witness that has personal bias against the defendant, you can show that. And so Mr. Blanche is continuing to do that. Yes. The redact, non-redact, redact, non-redact was very confusing. I agree, Pittsburgh. Right. So, right. So the original version had been approved by the state, and then the redacted version had not. She wants the whole point of all of that was that she wanted the entire context so that you could see. Because if you just take a couple of sentences out of a whole conversation, right, it's going to be very different than the full conversation. And so what she was saying was, if you want to put this in, you need to put it in the full conversation, because we don't want this to be an incorrect showing, an improper showing to the jury of what's actually going on. So that was really what that was about. Is it considered just a hostile witness? So great question. A hostile witness, technically under the rules of evidence, is your own witness. If you call your own witness and your own witness turns hostile towards you, meaning they won't answer any of your questions, then you request the judge to term them a hostile witness, which means you can do a cross-examination technique questioning. So hostile witness is a very specific term. So Mr. Blanche is already doing cross-examining, which is what you do for a hostile witness. So all cross-examination is seen as the witness being hostile. Through the whole trial, that's why. Well, right. I mean, it's a criminal trial, everybody. It's definitely a criminal situation. Do you have a guess on the verdict? No, I truly don't. I mean, flip a coin, truly, everybody. That's probably the most asked question that I've been getting. And it's a valid question. I get it. But, I've tried so many criminal cases, everyone. I've been in front of so many juries that I can promise you there is truly, truly no way to know. And I learned this the hard way, where, I walked out of a courtroom and I thought, all right, that's it. We got it. Slam dunk. This is it. Why'd I even come in today? We're done. And the jury came back with not guilty, and I just fell out of my chair. Meanwhile, I've gone into cases where I'm like, wow, I totally blew this. This is absolutely blown. I screwed this up. This is done. And they're like, well, we're going to do 5 years prison. So, we're going to find him guilty. The judge does the 5 years prison. And, I've been like, okay, all right, I'll take that. I'll take that win. So there's really no way to know. It's kind of like a test. If you go in, you're like, oh my gosh, did I fail? Did I pass? You may have some idea, but with a jury, you got 12 random people. There's just no way to know. Wants to use Cohen's bias to insinuate that he had a motive to lie to get Trump. Absolutely. So having a bias is a huge issue. It's a huge issue when testifying, and it goes to credibility of your witness. If your witness has a bias against the person they're testifying against, maybe the witness isn't completely being truthful because they're too biased to be able to tell the truth. So maybe they think they're telling the truth, but they can't tell the truth because they're biased. So it's a very it's a classic way of getting to the whether or not to believe your witness, the credibility. Any chance on a plea? No, we're too late for a plea. Well, I suppose technically if the jury hasn't received it, but I wouldn't believe for 1 minute Judge Mershon would accept a plea at this point. I think even if the parties discussed it, Mershon would be like, nope, we're done. Did I mention Cohen lied? No, I think Cohen mentioned Cohen lied multiple times, just repeatedly over and over and over again. Was so publicly vocal because his life and his family were being threatened. Could be. I think Miss Daniels had testified to something that I think is very true, and that is when you feel like your life or your family's life could be in that danger zone, to go as public as humanly possible in order to make yourself basically untouchable. So that could be part of the strategy. I mean, we don't know. We don't know. Much friendlier towards how Cohen looks. Oh, I know. I've got several Cohens. Oh my goodness. Yes, I do. And this one I thought was pretty good. I like this one because we've got Mr. Blanche here doing his, his assertive, his aggressive cross-examination here. Costello. Now, I don't know if Costello lied or not. Costello is a whole different bag of beans. That person's in some trouble. Yeah, he's gonna have some. He's gonna have some issues. Oh, hello, Kristen. Hello. Oh my gosh. Oh my gosh, that's so funny. Ah, how did you view Costello? I view Costello as someone who has forgotten that we are a country of laws. I mean, that's the thing is that everyone who's like, oh my gosh, the judge is biased and everything is biased is like, so did you want to pick one? I mean, because we got to have some laws here. We got to have some kind of laws or we won't have any order. It'll be anarchy, everybody. Anarchy. So, like, okay, you pick the judge, I pick the judge. Who picks the judge? Well, we have a process. You don't trust the process. All right, well, so we've got a lot of issues going on with that. Well, Lottie break. Well, you can read the indictment, which I think sets out all of the laws pretty clearly. If you're curious, it is indictment number here, which is 71543-23. So that's the grand jury indictment right there. All the laws are listed there. Yeah, I mean, I'm not indicting him. It was a grand jury in New York that indicted him. I'm just reading it. Oh, I know, hopped up on Mountain Dew Anarchy. Oh, I know. I know, everybody. I'm like, well, which laws do you want to use? Because the law is the law again. So if you don't like the law, change the law. I mean, that's right. So go for it. Change the law if you don't want it. Make Cohen look better. I agree. I think Costello did make Cohen look a lot better. I think Costello was a bad choice. I think he was an incredibly bad choice for the defense. Now, again, I wasn't in the room. But I from what I've heard, I don't know. If I was a prosecutor in that case, I would have been like, oh, thanks for that. But again, you still don't know, everybody. You still don't know. Asking about flag number 1 and flag number 2. Oh, sure. So, there's been a lot of talk about because Cohen's been on the stand quite a lot, and his cross-examination was very long. So what I'm doing as I'm going through this is, from the point of view from a prosecution point of view, and from what I think the jury may have taken as a flag from Mr. Cohen's testimony. So we've had some people come in and say, oh, I think this was the part where the defense got a punch in here and there. And so these for me are where I think Cohen didn't do himself any favors. So I've got 2 flags so far. The first flag that we talked about yesterday was when he kind of was having a little bit of a word spat with Mr. Blanche about what the word lie means. So I think that was the first flag. And then the second flag here was when he was talking about how somehow, he wasn't given a fair shake when it came to his sentence being reduced. So those are the 2 flags I've seen so far. So I'm just kind of noting as I'm going through this because there is so much of his testimony. Of course he's going to have flags. Everybody's going to have flags, everybody. They're not flags that be like, oh my gosh, that's it, he's done. No, they're just what I'm noticing, based off of my decades of experience. I won't say exactly how many, on what I feel would have been some hits against Cohen here. What crime? Right, why do people keep asking that? There's an indictment, dude, right there. This crime right here. This crime listed in the indictment. Saw for a whole day my attorney handled in the morning. Yeah. Give Cohen up to agree. Right. You're doing all right, Navy. Oh, the bots. Is it the bots? Yes, sir. Should have said yes, adding the sir. Well, it could be. Sometimes you just get into a certain way of, acting, a certain way of reacting, and especially after so many hours. That's a classic interrogation technique for anyone who's been trained professionally in interrogation techniques. That's a classic technique, is that, after that first hour, or even after those, if you do it right, even after that first 25 minutes, then, after you've offered the sandwich and the water, now you start getting to it. And the only way to really combat that is to have something in place to answer so that you can feel comfortable that no matter what your answer is, you're going to be protected. Feel the prosecutor met their burden. I think they did a good job. I don't know what else they could have done. Did they meet their burden? That will be up to the jury. And I just do not know. There's just no way to tell the jury. How long does it take between the verdict and the sentencing? Great question. It's different in every case. There has to be some kind of assessment of what would be the most appropriate sentence, and then it would have to go in. Since you're an attorney, how can a misdemeanor be charged as a felony? A misdemeanor, misdemeanor and a felony, you can be charged as a felony, but it can actually be seen as a misdemeanor. It doesn't mean that the charge was incorrect. It just means that your fact finder found it at less than what your charging person set it at. You can have a grand jury indict on a felony, and then you can have a petit jury or a trial jury convict under a misdemeanor. It doesn't mean either of those juries was wrong. It just means you have two different sets of fact finders. Oh, I know the artist is amazing. I know our artists are so... Can the jury lower it? Oh, great question, Lisa. So you can have lesser included offenses, everyone. It has to be, first of all, it has to be in the jury instructions. It has to be approved by the judge before it's even a part of it. Like they're not given these are different things that you can toss in if you prefer. It all has to be approved through the jury instructions. So if it's approved through the law, if it's possible and it's been properly requested and ordered by the judge in the jury instructions, if a lesser included offense is included, then the juries can consider that. But sometimes lesser included offenses aren't appropriate in some situations. They're just not appropriate and the judge won't include them. This is an appealable issue. If a lesser included offense was not given to the jury to consider in the jury instructions, it can be appealable. And there have been cases that have been reversed on that issue, that it should have been included. So to clarify the law. So it's a legal structure where the judge makes a legal call on whether or not it's appropriate to include it. Can't use their professional skills while deliberating. Well, I think, I think it goes true for anyone in a jury. Like if you're a doctor on a jury, you don't necessarily want to be in there explaining exactly how blood typing works. Like you should just know the information that you're getting within the four corners of the courtroom. I don't know. You can't ever truly separate yourself from your lawyer skills because being a lawyer is about how you think. It's not about, knowing which physical tool to use, because the tool of our business is our brain, and we use our brain when we're deliberating, right? Would that be an abuse of discretion standard? Yes, you could use abuse of discretion. That would be an appealable issue. Again, this is not legal advice, everyone. I'm just giving general information about the law here. But if you had an abuse of discretion, you could say that a lesser included offense was not included. That would be considered under there. I enjoy you. Do you agree that you can indict grilled cheese? I think legally it has to be a human, living human that has to be indicted. Legally, but you can put whatever on the paperwork that you want. As an enhancement, previous guilty verdict. Yes, exactly. Well, Navy vet, that's a great point too, because there are enhancements that are included. Sometimes those enhancements, though, the juries don't know about, depending on what the charge is. Sometimes the enhancements only come in to play during sentencing, and the judge is the one in charge of the sentencing, not the jury. Sometimes the juries do have some kind of sentencing if it's a bifurcated trial. So it depends. It depends on the situation. What crime caused a misdemeanor to become a felony past its statute of limitations? That's very specific. And that's a very specific question with, I don't have enough information. Will grant a stay pending appeal? Good question, Estelle. I've got no idea. I have no idea how this judge is going to do that. You might need lactose intolerant grilled cheese. Fair enough. Yeah, the bots are strong today. I think Jack is watching this case. I think Jack's got a lot on his plate, but yeah, I think he's definitely keeping an eye on it. Definitely. The defense cast a little doubt. Remember O.J. Simpson? Well, right. And, beyond a reasonable doubt, everybody, I get it. So beyond a reasonable doubt is a huge standard, and it's a very high threshold, and it has to be. And you have to keep in mind, I'm worried that one juror is not going to convict, so we're going to have a hung jury or whatever. I'm worried about that. But you have to understand, this is the standard we use for every single defendant in the United States. So if you think about it, if you know anyone who has ever said, I was wrongfully charged, and they put on the evidence and that one person came back and said, I don't believe that this person did it, and so that innocent person wasn't convicted, that's why we have beyond a reasonable doubt. So it's worrisome, and we do worry, but we have to have that high of a standard in order to prevent innocent people from being convicted. So it's troublesome, but we use it for everybody. It doesn't matter if you shoplifted a sandwich, or if you did, insider trading, or if there were 6 bodies in a freezer. You have the same standard, the same beyond a reasonable doubt that every other person has. And we have to have it that way, so strict in criminal court, because we want to make sure we do not have innocent people being convicted. It's very difficult. Has their notes, evidence, transcripts. Right, exactly. When talking to each other. So will they have their notes when they're talking to each other? That depends on the jurisdiction, and I'm not sure what they do in New York. I'm really not sure. I wish I could say one way or the other. It's interesting because even if you're looking at the Murdoch case, when they're talking about the notes the jurors took in that case and what they were able to use during their deliberations, it's going to be very different in that state versus New York. So it will depend on the jurisdiction. That still doesn't prevent innocent people from being convicted. True, it doesn't, but it certainly helps, though, doesn't it? It certainly helps. And that's why when people say, well, our innocent people are convicted all the time. Well, it's not all the time. It certainly isn't never, but it's somewhere in between. And it's because we have such a high burden of proof. It doesn't mean it doesn't happen, but it doesn't mean that it's, that it happens every day. Because we have to be so careful. We have to be so careful. Yes, the wet gloves in the OJ case. Yes, that was really the key. If the gloves get wet, then they don't fit. But that doesn't have the ring to it, does it? Do you think the punishment will be light because it's Trump? No, I really don't. I think the judge will do an appropriate sentence based off of all of the factors that are considered for every defendant. So history, all kinds of recidivism, what kind of harm to society, the danger of having him out. He'll look at all of those factors, I think, in order to figure that out. And I trust Judge Merchan. I think he's doing a pretty good job. I thought he did a good job in the case with Trump, the Trump Corporation as well. So, his record's pretty good. Yeah, you never know. I mean, you just never know with jail time. I mean, again, we talked about this before. We had 3 amigos in this scheme. We had Cohen, we had Wesselberg, and then we had Trump. Now, 2 of the 3 were given some prison time, but they had other issues going on. So will the 3rd amigo get it? I don't know. Will he be convicted? I don't know. Are there sentencing minimums? So, minimum would be 0 to 4 years per count. And then I think there's a minimal fine that's included in it. But again, in New York, I'm not sure. It would be a Class E felony. So if you pull up New York Class E felony minimum penalty, you should be able to see what the amount of fine would be. Is Trump well, it seems like it. Have immunity. I don't think so. I don't think he signed an immunity agreement with anybody. It's a true Cohen admitted to committing grand larceny. I don't know yet. I've not read that yet. I'm hearing lots of buzzing about that. I'm going to be very interested to get to that part of the transcripts, so we can talk about that. Cohen for the theft of the $60,000. Yeah, I don't know. I've got to get more details on that, everybody. I know that's a hot topic right now. But for me, I just don't have the information yet. Jury deliberating? No. No, we're not done. We're not done yet with the trial. There's an immunity case in front of SCOTUS. True, Brianna. And at some point, we're going to get a decision within the next few weeks. So we will see. Okay, great motivation for upcoming shows. I don't know. Yeah, right. Transcript for the 20th. Just thank you, VC, for that. Thank you. Yeah, I mean, reminds me of the jury name. Right. Second step independent journalism. Yeah, so, oh my gosh, journalism, everybody. I mean, come on, the media, come on. I cannot emphasize this enough. since the beginning of humanity and our ability to write, I don't know. All right, let me be careful about this. Since the beginning of being able to preserve language, we've had media issues. All right? All right? So, like, who was the town caller, right? So we could say, okay, the town caller was the New York Times or, whatever. Meanwhile, the next tribe over, it's the Fox News person, like, gather around, let me tell you a story. Like, we've got historians, we've got journalists. Like, they're always giving, like, come on. I mean, we've always got problems. We've always got problems in people viewing journalism and the media one way or the other. And it has always been that way. Like, the Egyptians are like, well, they didn't record that correct on the hieroglyphics. You know what I mean? I mean, they're like, well, that's really, sensational way of talking about Orion. I mean, come on. It's always been that way. So I just think, it just kind of is what it is. I'm not sure how we're going to be able to ever address that. I mean, right? Oh, you think the prosecution met the burden? I don't know. That I just don't know. I don't know. I think the prosecution did everything that they could have done. Whether or not they met the burden, we'll see how the jury feels about it. That's kind of my thought. Yeah, we'll have. Yeah, I mean, I know that's a terrible answer, but it's just because I can't call it. I just can't call it. I've seen too many trials where I've tried to call it and I was totally wrong. So it's like I've learned. I've been burned too many times, everybody. I've been burned. We've been exactly since the dawn of time, Suze. I know, right? So I was reading through, because I go through a lot of American history. I just, I think it's important to look at our American history here. And we had, so Paul Revere, right? Everyone, I know you can all go if it's okay. But Paul Revere, right? Do you know Paul Revere did a sketch on the Boston Massacre? All right, a sketch. And it was so overblown and so exaggerated that it was one of the starting points of the revolution. So, I mean, talk about media blowing something up. Paul Revere. So, I mean, come on. For me, I can't go and say, oh, the media, it sucks. I just can't do that because it's just always been that way. It's just not, I don't know how to fix it, how to change it. And I think we should always be talking about it. But I think it's also not the end of the world. I don't think it's the end of the world. Is that great? Is it one of the wildest ones of the week? We got Paul Revere writing in with his sketches. We got the Egyptians. Experience tried slammed. Oh, absolutely, Momo. Absolutely. If someone is like, well, that's it. We're done. It's over. That's it. That was it. Then it's like you've not been burned. You've not done enough trials where those juries have come back and you just sat there and been like, well, all right, that just happened. Or I've never lost a trial. Exactly right. Revere was very dramatic. He really was. And it's like, everybody was like, ooh, look how bad it was. Like, well, wait a minute. Why don't you go get the facts first? Get the facts. I'm not saying it wasn't bad. I'm just saying get the facts. Oh, my goodness. I don't know. I'm just saying, that, it's one of those situations. So it's not the end of the world. I think what's made it social media now social media, I have to say, there's a difference between, all right, let's just put it out there. There's a difference between writing some stuff on a wall in a pyramid or in some sacred place and having someone dig it up later, or the gods, however that works in Egypt. Oh my gosh, I don't mean to be offensive. There's one thing to write it that way on a wall. It's another thing to write it and have it seen by 1 million people in 20 seconds. You know what I'm saying? Like Paul Revere, just a small little group of people who had access to papers. As opposed to now where everyone, all over the world, someone in Iceland's like, hey, what's going on? Why did that not pass in the North Carolina legislature? Like, what? That's a huge difference. The speed of information. Absolutely. Makes it even easier for us to just be so quick about it. I think the basics are the same. The basic issue is the same, but the speed is different. Yes, technology. Oh, I know. I'm like, oh, those whippersnappers with their technology. No, I don't think it's a bad thing. I think it just means with all that extra time that you save by not having to like take a boat to Iceland, you should be doing some research, right? Use that extra time for research. Never mind. We'll see. I'm digging a hole. I'm digging a hole. I gotta be careful. Every once in a while, I dig a hole. The amount of information. Yes, exactly, exactly. Yeah, no, yeah. I mean, there's just really no way to know until our jury comes back. Oh my goodness, I'm just digging a hole here. Oh my gosh. What would you think Trump's win? Well, yeah, I don't know. I don't. Mr. Trump really, winning's very important to him, and it doesn't matter what it is, and it doesn't matter how you do it either. So, however, and with whatever, 3 weeks later, receive it by horseback. I know exactly. I mean, Marbury versus Madison established our judicial review, and it was all about the horses weren't able to get to everybody. Like, come on. But yeah, I think. Yeah, he likes to win, and I feel like if we could just give him like a little like trophy and have it engraved with his name and be like, you've won, okay, you can retire now, you've won everything, you are the winner of the world, now go retire. I think that would be great. I think we should all just chip in and do that. You aren't smarter. That's a good point. But see, if that's all he needs, if it's not actually like the quality of the win, it's just the win itself, like it's like fine, give him his gold star, give him the sticker, give him his free lunch and let him go. he wants to go and do that. Oh my goodness gracious. All right, with that, everyone, I am noticing the time here, so I have been on for quite a while. So I have had to change my schedule a little bit, everybody, because of my summer schedule here going on, but I will again need to be just for the next few days. My schedule will be just a little bit off. I will do an announcement a couple of hours before I'm able to pop on. I will not be able to come back on again tonight, and I'm not sure if I'll be on in the morning tomorrow or in the evening. So you'll just have to. Tomorrow's a weird day, so you'll just have to kind of watch for a post. I apologize. I apologize for that, everyone. But we should be back into the summer schedule within the next few days. But I really do want to come on as much as I possibly can. Thank you, Aaron. I do want to get more of Mr. Cohen's transcripts read here. And of course, keep an eye on my tube of you. I will have one post each day for the next few days. So I will go ahead and sign off for now, everyone, and I will be back as soon as I can. Yeah, you too, Navy Vet. Take care. Have a great day, everyone, and see you all very, very soon. Hopefully, you've all been able to have a couple of chuckles with me today. So have a good one.